Yes.
My lords and lady, I take this off. Sorry.
Yes, of course.
I appear together with Professor Ryan Abbott on behalf of the appellant, Dr. Stephen Thaler. My learned friend, Dr. Stuart Barron, appears on behalf of the respondent, the Controller of Patents, Designs and Trademarks. Please, the Court.
Yes, just to assist you, I can tell you that all members of the Court have read the two decisions below and the two skeleton arguments, so we're pretty well up to speed with the issue.
Thank you very much indeed. Thank you. With the Court's permission, I will lay out the key issues raised in this case, provide some relevant factual background on the UK and EPO applications, which have been mentioned in these proceedings, address why it is that patents should be permitted for AI-generated inventions as a matter of law, and discuss why we submit that in cases where an AI system, rather than a person, is the actual deviser of the invention, it is appropriate to identify the AI system as the inventor. My friend, Professor Abbott, will then discuss the issues of entitlement, the place of this case in the broader discussions about AI's impact on the law that have been raised in these proceedings, the policy behind protecting our AI-generated inventions, and what has been happening in other jurisdictions. Again, that has been mentioned in the skeleton arguments. I expect our submissions on behalf of the appellant will take a couple of hours, and that should leave my learned friend, Dr. Barron, sufficient time to make his submissions on behalf of the respondent, and hopefully time for the appellant an opportunity for reply, if we may have that. I'd like to start. I presume I don't need to bring you up to speed with what the inventions are about, and that it's not particularly relevant to this case.
Does it matter?
It doesn't matter.
We are required to assume,
yes,
firstly, that there is an invention in each
yes.
of these two applications, and secondly, that Dr. Thaler is correct when he says that the inventions were made by his machine Birss.
Yes.
So those are our starting assumptions.
Wonderful. Thank you very much for that assistance. And obviously that is a position that was adopted by the controller in the original decisions. The controller agreed that that Birss was the actual deviser of the inventions, and also that on the basis of the information that Dr. Thaler had provided, it thought that it would be virtually impossible for Dr. Thaler to deem himself the inventor as opposed to Birss. I'd like, if I may, just spend a little bit of time in looking at the designation of inventors that have been filed, because I think it is relevant for the later consideration of the issues of this case. And I'd like to refer to the supplementary bundle at tab C, which is the history of the filing of Patents Form 7. I will go through the history of only one of the applications because it is, in effect, identical between the two applications. So at tab C1, and this is at page 52 of the supplemental bundle, Dr. Thaler filed, or it was filed on behalf of Dr. Thaler, an addendum to the standard Patents Form 7. And in that addendum, Dr. Thaler explained how the invention was made, namely by Birss, which received general knowledge in the field and proceeded independently to conceive of the invention. It also indicated why Dr. Thaler should be deemed the owner of the invention by ownership of the machine. Now, as it happens, Dr. Thaler not only owns Birss, but is a person who designed, built, and operates Birss. There is no other person involved. And in the addendum, it was also explained why it would be wrong for Dr. Thaler to nominate himself as the inventor, since he had not actually made the invention. At tab 3, and this is in August 2019, following an objection by the UKIPO, a replacement Form 7 was filed, in which a note was made, and this is at page 59.
Just a moment.
Yes.
Just going back to where you were before.
Yes.
I had noticed that at page 53,
Yeah.
at the bottom of the page,
Yes.
the statement is made, in the present application, we submit that Dabbas should be acknowledged as the inventor of any resultant patents, with Stephen Thaler, the machine's owner, as the assignee of any such patents.
Yes.
So it seems to have been put forward at that stage, at any rate,
Yes.
on the basis of him being an assignee, although I can't see reference to any actual assignment.
I think that was an error, my lord. It shouldn't have been. There shouldn't have been mention of assignee as the owner of the machine and the owner of the output of that machine, which is obviously something that we shall come to when we discuss entitlement. But I thank my lord for pointing that out, and that was an error.
Well, you say it's an error, but you're saying we're to disregard that statement, even though we must assume to be true the other statements made in this Form 7.
I think it was the intention was clear in the addendum that Dr. Thaler considered his entitlement to the inventions by virtue of ownership of the machine, and that no assignment is required, but also no assignment could be provided, could be effective, when actually the inventor is a machine that has no legal personality, has no rights.
All right, so what you're saying is it's just a misuse of the word.
Correct, yes.
All right, thank you.
Yes, indeed. So at tab C, subtab 3, so it's at page 59 of the bundle, the replacement Form 7 was filed with some additional text at the bottom of that form. And that additional text stated, the applicant identifies no person or persons whom he believes to be an inventor, as the invention was entirely and solely conceived by Dabbas. Pursuant to section 7.3 of the Act, Dabbas is the actual deviser of the invention and therefore rightly named as the inventor on this patents form in accordance with the requirements of section 13 of the Act.
Oh, sorry, Mr. Chair, which page are you on now?
On page 59,
59.
supplemental bundle. C3.
Oh, I see. It's that tiny text. I've got it. Yeah.
Yes, indeed. Yes. Now, since the filing of these forms, the debate has moved on, and I'd like to come to that when we consider where the debate has got to in the course of time from the filing of this form to where we are today. But there was a clear statement here.
Sorry to interrupt you, but
Yes.
since we've got this in front of us,
Yes.
Can I just ask a question before I forget
Yes.
it? And to some extent, this is anticipating matters you or Professor Abbott will be coming to later, and I apologise for that. But since we've got it in front of us, it's nevertheless convenient to ask the question now. This seems to accept that the requirement under section 13 did require identification of Dabbas. So it's not an acceptance that section 13 required identification of any person, but it seems to be an acceptance that it did require identification of the actual deviser, namely in the machine.
That is our submission, my lord, that if there is an identifiable inventor, that inventor should be identified.
Why?
It's relevant for a number of reasons, primarily to inform the public, to inform third parties that may wish to claim rights in the invention. Let's just say, for sake of argument, if Stephen Thaler was solely the owner of Dabbas, could a third party claim some rights in the output of Dabbas, the creator of Dabbas, the programmer of Dabbas? Could they claim rights in the output, in any inventions that may come out from Dabbas? So to identify the actual deviser of the invention, I submit, is something that is important. Now, the debate, as you know, I've mentioned, has moved on, and we will come to that, to a suggestion that when an invention has been made by an AI machine, you shouldn't name any inventor at all. That's fine, but it doesn't give the public, it doesn't give third parties, people who potentially have rights in that patent application or patent, the information, all the information that I submit they ought to have.
All right, well, we'll need to come back to this when we look at Section 13, but
yes,
my initial reaction is that's a bit odd to suggest that the function of Section 13 is to inform the public. I mean, on the face of it, it's conferring a form of moral right. In the jargon of moral rights, it's a paternity right.
Yes, it's both. Obviously, a person who is an inventor has moral rights. A machine has no moral rights, not at the moment, unless obviously the law changes. So we have a situation here where, yes, without a doubt, you know, if it is going to be accepted that inventions made by AI systems in principle could be patented if the inventions meet the other requirements of patentability, then the Act needs to be construed in a way that we can accommodate the situation of an AI machine being the actual deviser of the invention rather than a person who may have other rights as well. And for instance, I do not submit at all that Dabbus has a right under Section 13.1 to be named as the inventor, because Dabbus has no rights, has no legal personality.
Thank you.
There are, and obviously the situation with respect to the light beacon patent application is the same. I don't think I need to go over, unless your Lordships and Lady wish me to, the passages in the original UKIPO decision that accepted that Dabbus is the creator of the invention. What I would, however, like to point out in that, and this is at the core bundle at K, at page 110, at paragraph 27, the hearing officer or the controller stated, given the clear statements provided by the applicant which indicate that the inventor is in fact an AI machine, it seems that it will be almost impossible to demonstrate that the actual deviser of the invention was in fact a person as opposed to Dabbus. The controller used precisely the same wording as in subsection 3 of section 7 of the Act. And obviously that is correct. In the facts that you have before you, Dr. Thaler has never contended that he is the actual deviser of the inventions and has never sought to claim inventorship. The words of Lord Hoffman in Yeda Research, and this is in the authorities bundle at tab 12, page 110. Again, this is paragraph 19. So paragraph 20. Use words that are very similar or the same. He says, in my opinion, therefore, the first step in any dispute... sorry, I'm reading the wrong paragraph. The inventor is defined in section 7.3 as the actual deviser of the invention. The word actual denotes in contrast with a deemed or pretended deviser of the invention. So we have an acceptance, I submit, that Dabbus falls within section 7, subsection 3, as being the actual deviser of the invention. And I'll come to, in a moment, whether or not subsection 3 of section 7, as section 13, are in some way limited to the inventor necessarily being a natural person, or whether the definition can be broader. But the principle is the actual deviser of the invention is a material and principle, an important principle set out in our Act. It is not something that could be treated lightly. For instance, you cannot have a distinction between an actual deviser of the invention and a legal inventor that may otherwise fit more comfortably within the other provisions of the Act. I submit there are three primary issues on the appeal. First, should an invention be generated, should an invention that has been generated without a traditional human inventor be granted a patent? I submit that that actually is the core.
Well, that's a policy matter, isn't it? I mean, what function is it of this court to pronounce on a question of policy of that nature?
It's not necessarily just a function of policy. It is a function of what patent law it exists for. Patent law...
It exists to incentivize
yes.
the making of inventions.
Absolutely.
By the grant
absolutely.
of limited monopolies.
Absolutely. And the incentive is to the owner of the invention.
Well, one might say the incentive is to people to devise inventions, to use the statutory language.
And for the owners of those inventions, the organizations, and ultimately most patents are owned by corporations, not by individuals.
But that's by virtue of the statutory machinery with regard to ownership.
Absolutely. But the incentive, the incentive is in the patent itself, is having the patent, and the incentive is to whoever provides the resources to make those inventions. A pharmaceutical company has the incentive to patent because it will own the patents and it will derive the benefit of that patent. The incentive isn't solely to the inventor, who may never own the rights to the invention, by subsection 2 of section 7, or 2b rather, of section 7. So it is, I submit, an important aspect that the incentivization is not to incentivize the inventor necessarily to make inventions, but the resources, the investment into the making of the inventions and who ultimately benefits from those inventions. And whereas it might be suggested that whether, or the concept of whether or not an invention generated without a human inventor should be granted a patent, it is a matter of policy, but it is also a matter of law. And we're here before you today because there are two inventions that happen to have been made by an AI system. While this may be the first case that our courts have had to hear, I don't think for one moment that it's going to be the last, and I suggest that there are going to be more of those. Just as in some of the broader policy considerations that have been identified by my learned friend, by the respondent, considerations such as infringement of a patent.
All right, but there are wide questions that potentially engaged once you get onto the level of policy, such as, yes, should one confer legal personality upon inanimate objects? Theoretically, one could do that, but it would have drastic consequences if one did. Even in the absence of conferring legal personality on inanimate objects, all kinds of questions can arise as to attribution of legal responsibility. I mean, take autonomous driving machines. What form of legal responsibility should, and upon whom should legal responsibility rest? These are massive policy questions that legislatures are going to have to grapple with. But why do they arise in this case?
Those policies do not arise in this case. We're not talking about a self-driving vehicle, for example. We're not talking about we're not suggesting that Dabbas should have legal personality to own the inventions. But may I suggest that it is not out of is not out of the the realms of feasibility that our courts could be faced with a defence by defendant that says, my lords, I haven't performed the infringing act. My AI machine has done so, so it is the AI machine that is liable to infringement. And this is one of the broader policy questions that has been set out in the respondent's skeleton. The question of whether or not an AI machine could be held liable to infringe may be something that Parliament ought to consider, but I submit that it is something that may very well come before our courts, long before Parliament even considers it. And I submit that our courts are perfectly able to consider a question of that nature. Another question may, for example, be the issue of obviousness. We have this notional skilled person who is the barometer for obviousness. It's not at all unfeasible that that skilled person, the team, if you like to put it that way, may include an AI system that performs some of that technical work. It may be creative technical work. So while there are broader policy considerations in respect of AI, absolutely, and it is something that not just our Parliament, but across the world need to consider, we are here in the realms of two patent applications. We're in the realms of the Patents Act, and the questions really are limited to that. We're not discussing other issues involving AI. And I submit that our courts are perfectly able to consider the question of inventions created by AI systems, just as they would be able to consider questions of infringement by an AI system. And I suspect the answer to the latter would probably be quite simple. But that's not for me to judge. So absolutely, there are broader policy conditions, but the question is looking at the Act itself, is there a prohibition or is there a requirement within the Act itself that creates an impediment to Dr. Thaler obtaining patents for these two inventions created by Dabbas? The second point I submit is that in the case when our AI system functions as the actual deviser of the invention, what or whom should be listed on a patent application as the inventor? And there have been various suggestions in that regard, which I shall come to. Third, of course, is does the owner of the AI machine, and in this case, as I've mentioned, Dr. Thaler is also the designer, constructor, and operator of the machine. He controls Dabbas. Who owns it? Does that owner own the inventions made by the AI machine? And as a consequence, is that person entitled to be granted a patent for those inventions? In respect of issue 1, I submit that there is no prohibition in the Act on granting patents for inventions made by AI systems. The respondent has not cited a single provision in the Act that says as such. Only argument that has been put before our courts and before your lordships and ladyship is that at the time of writing the Act, it was only contemplated that natural persons would be inventors. That is the argument that's been raised. Neither does that constitute a prohibition in the Act, nor is it supported by the express wording in the Act. The argument relies on how other terms used in the Act, specifically in sections 7 and 13 that I shall come to, ought to be construed. And specifically, the respondent argues that these sections of the Act must be construed as being limited to a natural person, even though the legislator chose not to use that term, and therefore chose not to limit the Act in the manner the respondent seeks to construe it. And I submit there is a world of difference between an Act of Parliament, particularly one focusing on inventions, not contemplating a technical advance and a prohibition in such an act. Furthermore, the implied prohibition that's suggested by the respondent appears not in a substantive provision of the Act, that's section 7.
Can I ask you this question?
Yes.
You place a lot of emphasis on what you characterise as the absence of prohibition in the Act, but does that assist you? Because the only way you can get a patent is under the Patents Act.
Yes.
There's no common law right to a patent. It's a statutory right.
Yes.
So do you not have to show that you have an entitlement to a patent under the statutory provisions? Simply saying there's no prohibition doesn't assist you, does it?
Absolutely. And that is a matter that my friend Professor Abbott will be discussing. And that is specifically in respect of subsection 2 of section 7 of the Act. So the question of entitlement, absolutely. So there's the one is there prohibition in principle, and the other one is actually the applicant entitled to the grant of a patent. And the implied prohibition suggested by the respondent appears not in a substantive provision of the Act, which is section 7, but in a procedural provision, which is section 13, and I should look at that.
That's not how I understand the controller's case. I understand the controller's case to start with section 7.
Absolutely. Well, in a way, and I'll like to point to a part of the judgment under appeal where actually reference to section 13 was used to explain a refusal of the application, or to indicate a refusal of the application, which is something that section 13 does not permit. So I think there are two issues here. One is, as a matter of principle, can an invention made by an AI system be patented? The second is, who would be entitled to the grant of that patent, if anyone? It may be that your judgment will be, or your decision will be that nobody.
That's how the controller would characterise the issues. My understanding at the moment is that the controller's position is that the first issue we have to decide is whether a machine can be an inventor.
Yes.
And the controller says no. The second issue is that if a machine can be an inventor, can Dr. Thaler qualify as an applicant under one of the provisions in section 7, subsection 2, and you rely on paragraph B, and the controller says you can't rely upon that. So that's how I understand the controller to characterise the issue.
Absolutely. And we will come to that. So I will be dealing with the first issue that Your Lordship has mentioned, and Professor Abbott with the second, the one of entitlement.
Thank you.
Now, in the provisions of section 13 are procedural provisions, okay, and this is to do with the first issue, whether, a patent should be granted for an AI-generated invention. Section 13, as I mentioned, is a procedural provision. I'm going to come to it in a moment. But also it doesn't apply to all UK patent applications or patents. The Act does set out a number of express prohibitions in sections 1 and 4A, or exclusions from patentability. The nature of the invention does not appear in any of those exclusions. I submit, therefore, that an argument that since the autonomous generation of inventions made by AI systems was not contemplated at the time of writing the Act, must necessarily result in the Act not catering for them, should be considered with caution. The whole point of patent law and the Act is to cater for and provide protection for the unknown and unforeseeable. That is the essence of invention, and patent law explicitly exists to provide protection for the unknown and unforeseeable. And while the assessment of new innovations may from time to time be uncomfortable in the context of a law written in 1977 and initially considered many years before then, our courts have not balked at having to consider previously unforeseen technological innovations. To the contrary, our courts have time and again construed or defined patent law to cater for such changes in the technological landscape. There are many examples where this has happened, for example, in computing and software, in genomics, medicine, and so on. I submit that the issue ultimately at hand is not whether a patent should be granted for such inventions, but how could it be granted? There's been no fundamental objection in these proceedings, or for that matter in proceedings in any other jurisdictions, to the granting of patents for inventions conceived by AI systems. The objection has been who should be named as the inventor, with the consequential question of entitlement, and that is a different issue. If I may refer to the judgment itself, the judgment under appeal itself, so that's in the core bundle at I, and particularly at page 99, and it's paragraph 49.3d, so it's just above the subheading conclusions. And the learned judge, in his judgment, said it would be far easier to contend that Dr. Thaler was entitled to the grant of the patent pursuant to section 7.2a of the Act, on the ground that he, Dr. Thaler, owned the machine that did the inventing. That would actually be a much closer analogy to the general proposition advanced by Dr. Thaler that if you own the machine, you own the output of that machine. And the learned judge quite rightly noted that this was not a contention that had been advanced by Dr. Thaler, indeed it's possibly not been advanced. And also over the page, at this page 100, and this is in subparagraph 2, as I have noted, the question of whether the owner or controller of an artificially intelligent machine that invents something can be said him or herself to be the inventor was not a matter that was argued before me. So the contention is, I own the machine and therefore I am the inventor. Now, leaving aside whether this would be legally or morally right, and I submit it would be neither, it doesn't satisfy section 7, subsection 3, or the findings of Lord Hoffman in Yeda, it would indeed superficially resolve the procedural requirement, or the procedural requirement of section 13.2 and the requirements of section 7, and therefore dispense with the problem. Now, the learned judge seemed to think there was little wrong with such a suggestion, and that would solve the problem of granting patents for inventions devised by AI systems. Of course, as a practical matter, however, that suggestion would fail to address situations in which the owner wasn't a person, a natural person, but a corporate entity, which I submit is probably a more common occurrence than a natural person being the owner, in particular in connection with ownership of complex AI machines. The Legal Board of Appeal of the European Patent Office, that's hearing the Davos EPO appeals, has likewise raised a point for debate, or as a point for debate, a route to avoid the procedural requirement of naming an AI machine as an inventor, namely not to name any inventor, to refuse to complete the designation of inventor, and therefore to enable the granting of patents for AI-generated inventions. And if I may turn to the core bundle at tab P, particularly at page 170, and this is 4 lines down from the top of the page. A decision dismissing the appeal and based on the above reasoning would not mean that under the EPC an application is to be rejected where the applicant refuses to indicate a natural person as inventor because in his opinion the invention was made without any causal human contribution. And then a few lines down, such a decision would mean only that the applicant, while remaining free to explain in the specification of the patent application how a claimed technical teaching was made, would have no right to indicate a machine as inventor in the form to be submitted in order to comply with Article 81 EPC. So the Legal Board of Appeal has so far not expressed any opinion that patents for such inventions should not, as a matter of law or policy, be prohibited. And actually what it is suggesting is a route around the procedural problem of naming a person. It doesn't address the issue of entitlement. It just seems to think, well, that's fine. Have your patent and be done with it. I submit also that there's no appetite, at least in the United Kingdom and in Europe, for denying patents for AI-generated inventions. If I may refer again at the core bundle at tab S at page 203.
Just incidentally, can I just mention, while we're on the subject of the preliminary communication from the Board of Appeal,
yes,
at page 169, we see that the preliminary view expressed by the board is that an inventor must be a person having legal capacity. And they say that legal capacity means the ability, according to a source of law, to be the subject of rights and duties. So they are not predicating their preliminary view upon a requirement that the inventor be a natural person, but upon it being a person recognised by law. So that could be a legal person.
Yeah. Okay.
So I'm not expecting any reaction to that now.
Indeed.
It's something to come to bear in mind later.
Thank you very much, Your Lordship. If I may turn to tab S for sugar at page 202. This is the 2020 AIPPI World Congress resolution of 9 October 2020.
I beg your pardon, could you give me the page reference again?
It's page 202 of the core bundle.
I have it, thank you.
This is the 2020 AIPPI World Congress, in particular page 203, at paragraph 2. An invention should not be excluded from patent protection merely because an AI contributed to the invention. And then at paragraph 204, page 204, paragraph 5, an AI should not be considered as an inventor or co-inventor of an invention, nor be permitted to be named as such.
I've lost you, Mr. Johan. Sorry, where are you now?
Yes, paragraph 5.
5?
Yes.
I see, sorry.
An AI should not be considered an inventor or a co-inventor of an invention, nor permitted to be named as such, even if no contribution to the invention by a natural person is identifiable. I should like to come to our arguments in connection with this in due course. Paragraph 6. In order to foster innovation, inventions made using AI should not be excluded from patent protection per se, regardless of whether or not there is sufficient contribution by a natural person to be named as an inventor, and provided there is a natural legal person named as applicant. Distinction there is made between inventorship and applicant, which is obviously absolutely right. If I may also refer to the UKIPO open consultation in the supplementary bundle at tab J. This is the UKIPO open consultation, and obviously the open consultation asked a series of questions. And the framework was to be granted a patent, invention must be new, not obvious, and something that that can be made or used. Page 221. Patents incentivize invention in two main ways. They encourage investment in research and development because as exclusive rights, they give the owner the opportunity to secure a return. Publication of the patent allows others to learn of technical advances so an invention can be further developed or worked around. The incentivization is to the owner who makes that investment. And if you're investing in very expensive new technology, obviously that needs to be considered. And at page 2, at page 222, as the inventor is considered the actual deviser of the invention, the question is whether AI could be considered as the inventor and should be named on a granted patent or on a patent application. That is a question that's obviously been posed as a result of these cases. And the government response to that likewise, and this is at tab L, likewise raises the issue of inventions made by AI-generated inventions and whether, as a matter of policy, it is, or law, such patents should be granted. At page 240 of that response, government says, we recognise that AI systems have an increasing impact on the innovation process. We want to ensure the intellectual property systems support and incentivize AI-generated innovation. So I submit that there is no wish to deny patents for inventions made by AI systems.
But how is that relevant to the construction of the Act?
I should come to that now, if I may, Your Lady. I would like now to turn to the Act itself, and in particular sections 7 and 13. And as I've mentioned, my friend Professor Abbott will address you in connection, in particular, with the issue of entitlement in section 7, subsection 2 of the Act. Section 7 comprises two different provisions in connection with the issues that we have at hand. One is a definition of the inventor, the other is to whom a patent may be granted. These provisions are not the same, nor are they inextricably linked. One relates to inventorship, the other to ownership. Ownership only derives once you have identified inventorship. Section 7, subsection 3, is a sole definition of the inventor in the Act, namely the actual deviser of the invention. No one who fails to satisfy this definition can be considered an inventor. It does not comprise a deemed or pretended deviser of the invention in the laws of Lord Hoffman in Yeda, and I've referred your lordships and ladyship to paragraph 20 of that judgment. A person, even though having legal personality and the ability to own an invention, or the rights of an invention, cannot be an inventor in the Act if that person is not the actual or an actual deviser of the invention. My understanding is that the respondent has sought to argue that section 7, subsection 3, by virtue of subsection 2, for example, requires the inventor to be a natural person. However, section 7, subsection 3 makes no mention of person, let alone a natural person. It is not written, for instance, that the inventor means the person or the natural person who is the actual deviser of the invention. The words simply are not there. Moreover, I submit that subsection 2 of section 7 cannot help, because subsection 2 relates to the rights to the invention, which must be owned by a person. We don't dispute that. And that is an entity having...
Just ask you a question about the submission you just made. You are, of course, correct that the word person does not appear in subsection 3.
Yes.
But as I understand it, is your submission that the actual deviser of the invention can be something which has no legal personality?
In this case, yes. Absolutely. The AI machine is the actual deviser of the inventions. And we accept that the AI machine has no legal personality. It doesn't as a matter of law.
So we are to construe actual deviser of the invention as embracing a thing with no legal personality.
In the words of Lord Hoffman, I submit yes, because otherwise we are talking about a deemed or pretended deviser of the invention in Lord Hoffman's words. And that is simply not right. And my submission is that the Act makes a very clear distinction in respect of invention. It's an inviolable principle that the inventor is the actual deviser of the invention, not anybody else.
Not be sure. Yeah. Okay. That's what subsection 3 says, as you pointed out.
Absolutely. And ownership and inventorship are not the same thing, and they're not actually subject to the same rules.
Mr. Johan, can I just make sure I've understood the point that you're making? What you're saying is that if the entity which devised the invention is not a legal person, a rule or a practice or whatever it was which said that the human being who owned and controlled the entity should be regarded as the inventor because they are a person, would be contrary to what was said by Lord Hoffman.
Absolutely.
What you're doing when you do that is you're pretending that a human being was the actual entity that devised the invention,
Absolutely.
even though it wasn't. That's the point you're trying to make.
Absolutely. And there's actually an analogy that could be made, I submit, with US law, the determination of inventorship in US law, where you look at the wording of the claims, the subject matter of the claims, and the inventors or, the people who wish to be named as inventors have to actually look through the claims and say, I contribute to this, I contributed to that. So there isn't a concept of a legal inventor as opposed to an actual deviser of the invention. Actual deviser is the thing, in this case, or the person who actually came up with the invention. And that is our starting point, as we established or discussed at the start of this hearing, that the UKIPO, on the basis of the information, representations made by Dr. Thaler, accepts that Dabbus is the actual deviser of the invention, and also accepts that Dr. Thaler did not. So he cannot name himself as the inventor, because he would be otherwise a pretend or deemed deviser of the inventor, and that of the invention. And that is contrary, surely, to the principles set out by Lord Hoffman. Now, there's been a suggestion, by the respondent, that Lord Hoffman, in referring to natural person at paragraph 20 of Yeda, that's at page 110, it's paragraph 20, in some way limited section 7.3 to the inventor being a natural person.
Well, he undoubtedly said natural person, but it's also undoubtedly the case that the word natural nowhere appears.
Absolutely.
But, I mean, does that matter for our purposes? Because for our purposes, we don't need to worry about the distinction between natural and legal persons, because Dabbus is neither.
Absolutely. Yes, Your Lordship, that's absolutely right. And also, it does not matter, because Yeda was not even distinguishing between natural persons or corporations as inventors. It was merely resolving a procedural point between competing inventors who happened both to be natural persons. We therefore submit that in respect of the reference to natural persons, these words of Lord Hoffman were dictum and cannot be used as determining this point of law. At best, the respondent has to imply within the Act terms that are not expressly used, specifically natural person. It's not used in section 7.3, nor in section 13, subsection 2. So I submit that section 7.3 cannot in itself be held to limit the concept of inventor to a natural person. While it is correct that at the time of the drafting of the Act there was no expectation that computers would develop to such an extent as to be able to create patentable innovations, it was actually the opposite. There's, I submit, as I've mentioned before, a vast difference between an expectation and a mandatory requirement of prohibition. There have been many types of inventions since the drafting of our Act in 1977, a vast number of inventions that were not predicted or expected at the time.
Is that actually right, Mr. Jain? I mean, I don't want to spend a lot of time on it because I don't think it really matters very much, or if it matters at all, it may actually be a point against you. But my recollection is that if you look for the right thing, if you use expressions like artificial intelligence, you won't find it. But if you remember that in those days it was called expert systems, Feigenbaum's expert system work was done in the 1960s. And the concept that computers could think and do the kind of thing that you're talking about actually was in existence. And it isn't right to say that it couldn't be foreseen that machines might be able to do that sort of thing, which, if it's anything at all, is a point against you, because if it was foreseen, then you might say, well, the Act didn't allow for it. But as I said, I'm not sure it really matters, but I have noticed that you've repeatedly said that it wasn't, and I just want to put down a marker that I'm not sure I agree.
Perhaps I could refer your Lordship to, take a little while to get to it. This is in the supplemental bundle, tab I3. That's page 204.
This is the Travo for the EPC.
Yes, absolutely. So, and this is paragraph 2G, or paragraph 96 rather. United Kingdom delegation proposed that computer programs should not be patentable, and it proposed a draft giving a definition of what a computer program was. It stated that a computer program was basically not inventive and was merely the mathematical application of a logical series of steps, a process which was no different from a mathematical method excluded under A.
That's got nothing to do with this, though. That says, when it says not inventive, it means they're not an inventive step. It's nothing to do with what we're talking about.
I think what it establishes, I submit, that at the time, well, maybe it was dreamt that computers could actually achieve some form of autonomy of thought, of creation. It was not something that was considered feasible at the time, or that there would need to be considered at the time. But nevertheless, the legislator chose not to refer to natural person in section 7.3, nor in section 13, and chose the broader definition of person in that regard. And as I shall come to, when I come to section 13, that is a procedural provision and not a substantive provision in law, and it requires a filing of a statement. Its sanction is not refusal of the application, but the application should be taken to be withdrawn. And I submit that there is a world of difference between refusal and deemed or taken to be withdrawn. And I submit that the legislator would not have sought to hide a substantive requirement for patentability all relating to the nature of the inventor, in provisions from which one must construe terms that are not used, by construction of the Act that requires extrapolation from separate provisions, and one of which is a procedural provision which doesn't provide any sanction but deemed withdrawal of the application. So put simply, the appellant submits that there's nothing in section 7 or 13 or anywhere else in the Act that makes the nature of the inventor, i.e. that the inventor must be a natural person, a substantive condition to the grant of a patent. The point is entirely consistent with the EPC. The mention of the invention is in the implementing regulations and not in the convention itself. And if I may refer, for example, supplementary bundle at tab I2, page 202 bundle, about halfway down the page, says, on the other hand, other delegations thought it was inappropriate to insert a fundamental subject, such as that of patentability in this case, in the implementing regulations which were subordinate to the convention. And also at...
Sorry, I don't understand what we're seeing this for, Mr. Jahan. This is about whether the rules on patentability should go in the convention or in the implementing regulations, and they said, somebody said there that they were important and therefore they should be in the convention, which seems sensible, but what's that got to do with the point?
It's to do with whether a substantive requirement to patentability should be in a procedural provision or in a substantive provision of the law. Okay? That is the point I'm seeking to make. And before addressing the issue of whether to be an inventor on the Act, an inventor in accordance with the Act, the inventor must have the ability to have rights. Would your Lordships and Ladyship wish to be addressed on the issue of state of mind of the inventor? It is a point that the learned judge raised in the judgment. I shan't address that if it is not of interest to you.
Well, at the moment, I'm not entirely sure what the point you're referring to is.
If I refer to the judgment itself, and this is at the main bundle, tab I, at page 96. It's at page 96. And this is at the last sentence of the paragraph that bridges pages 95 and 96. And the judge says, there's some sense in keeping the definition of the invention close to that which must arise out of the mind of an individual. So the question is whether the learned judge and whether you might wish to be addressed on the question as to whether or not the mind, the state of mind of the inventor is something that needs to be considered when considering the question of inventorship. It hasn't been debated in these proceedings, but it was mentioned in the judgment.
Well, I think the point that's being made here is that a supporting consideration as to the proper interpretation of the word inventor is that when you look at the substantive requirements as to patentability, which are written into the EPC and hence into the Act, one of the key substantive requirements is that of inventive step. And inventive step is defined in section 3 as something that is not obvious to a person skilled in the art. So this is yet another statutory reference to a person. And therefore, what is said is that this is further support for the notion that an inventor must be a person. And as we've discussed already, whether it's a natural or legal person doesn't matter for present purposes.
Yes. If that's the case, may I make two submissions on that point? The first is that the law does not require an inventor to have a particular state of mind, nor does the law require the inventor to explain how they arrived at the invention. There's no requirement to set out, should we say, the invention story. They don't have to explain themselves. The test for obviousness, for inventive step, as your lordship has identified, is in section 3, and that is obvious to a person skilled in the art. Now, it is an established principle of law that a person skilled in the art is a hypothetical person and may be a group of people. So it's not actually a natural person, may not even be a person with legal personality. It is a legal fiction.
Well, sorry, that doesn't follow at all. The fact that there can be more than one natural person doesn't in any way show that you don't have to be a person at all.
Does the question of inventive step also encompass the possibility of an AI being part of that team? It is not an issue that's in these proceedings.
No, it's not.
But it is an issue that may well come before the courts. And if the courts hold that, for instance, section 3 of the Act requires the threshold of obviousness of inventive step to be only to natural persons, a group of natural persons, without the assistance of AI, surely that risks skewing the test for obviousness.
That's not what we're concerned with here, as you've rightly pointed out. We're not concerned with a team of which AI is a part, nor are we concerned with the human inventor using AI as a tool. So what is your submission as to the proper construction of section 3 of the Act when it refers to not obvious to a person skilled in the art? Is it your submission that person in that context can include a thing without legal personality?
It may do, yes. It may well do. It's obviously, it's a hypothetical person. And we are at the stage even now that a great many technologies require the input of AI in part of that process, i.e. that the AI can perform certain functions that are beyond that of the capacity of the human brain. My submission is absolutely, even though we're not talking about obviousness, that it is not inconceivable that the test of obviousness will at some stage comprise AI within that team.
Mr. Chan, can I tell you what troubles me about this aspect of the debate that you're advancing? It's the point that you made earlier that the subjective manner in which the invention was devised is not, I mean, sometimes it plays a part in some patent cases, but as a matter of law, it's not actually relevant to the question of whether an invention involves an inventive step. If inventions had to be not obvious to the person who invented them, an awful lot of them would fail, because in fact most inventors think the invention was obvious to them.
Absolutely, yes.
It just isn't obvious, let's say, to the person skilled in the art. And so I'm struggling to see why it's a relevant consideration to examine section 3 at the moment at all.
I agree entirely, absolutely. I think the state of mind is not something that should be considered, absolutely. I just wanted to point out this comment and the judgment and whether you wanted me to address you on it. But I agree with your Lordship, absolutely. State of mind is not relevant. The next issue is, to be an inventor, does an inventor have to be able to have rights in the invention in order to be an inventor in law? And that's whether the inventor needs to have legal personality. And that's obviously something that the original decision of the controller relied upon, and also the decision of the learned judge that's under appeal. An inventor can only derive rights for reason of being an inventor. That's a starting point, I submit. And it's entirely consistent with Section 7.3 and also with the finding of Lord Hoffman in Yeda. If I may refer, and this again is in the authorities bundle at tab 12, and it's in particular at paragraphs 19 and 21. Paragraph 19, page 110. Paragraph 19, what Hoffman states, in my opinion, therefore, the first step in any dispute over entitlement must be to decide who was the inventor or inventors of the claimed invention. Last sentence of paragraph 21, there's no justification in a dispute over who was the inventor to import questions of whether one claimant has some personal cause of action against the other. What I submit is that the test for inventorship has to be the first test that is applied. Who is the inventor? From that determination, then the rights can be determined. And indeed, Lord Hoffman says that, in paragraph 18, says, in saying that a patent may be granted primarily to the inventor, Section 7.2 emphasizes that a patent may be granted only to the inventor or someone claiming through him. Now, obviously, we will address the meaning of claiming through him, but the first step obviously has to be inventorship, and then we decide the question of entitlement to the grant of a patent. And that is something that Professor Abbott will address you on in due course. I'd like to point briefly also to Section 7.4 of the Act. And this stipulates that except as so far as a contrary is established, a person who makes an application for a patent shall be taken to be the person who is entitled under subsection 2, above, to be granted a patent. And this is obviously a matter of how the Act is then used. And Section 7.4 states it as a mandatory requirement that the applicant shall be taken to be the person entitled unless the contrary is established. Now, I submit...
It's a rebuttable presumption.
It is a rebuttable presumption, but may I suggest that how is it rebutted in law? And if I may refer again to the words of Lord Hoffman, it's at page 106. And it's at paragraph 6. The Patents Act contains procedural machinery for determining disputes over who is entitled to a patent. And at paragraph 8 over leaf, it's at the bottom of page 107, noted that also subject 1 lists 3 questions. The only substantive question is who is or are the true proprietor or proprietors. My submission is that what Section 7, subsection 4 of Section 7 requires ultimately is the identification of who else is entitled to those rights. Does subsection 4 of section 7 provide the office with the ability or the right to say nobody owns the rights to this invention? And that, I submit, as a question for your lordships and ladyship to decide. I would be very concerned if the decision is nobody owns those rights. We shall come to that in terms of policy.
But of course, that way of the question you have posed there assumes that there are rights in an invention. So let's assume that an invention has been made, and let us also assume that no one has yet even thought of filing a patent application in respect of it. Is it your submission that there are rights in respect of that invention? And if so, what rights are there?
My submission actually is that there aren't any rights to that invention. If I keep that invention secret, and somebody else comes up with the same invention and files a patent application before me, I have no rights over them.
Indeed.
You have a right to it, don't you? Isn't there someone who has a right to apply for a patent? The key thing is apply for. The example you've given, if you were the second person to get to the patent office, is that you wouldn't get a patent because your patent would be anticipated. But there is still, when you make an invention, when an invention is made, or when you make an invention, there is a right. The right is a right to apply for a patent. And someone, at least in the normal case of a human being inventor, someone has the right to apply for a patent for that invention at the moment you create the invention. In fact, even before, possibly.
According to the Act, anyone has a right to file a patent application. You don't need to have the right to be granted the patent.
Right.
So,
But just because anyone can make an application and Section 7.4 has a rebuttable presumption that they have the right is not the same thing as saying that there isn't a right to apply for a patent for an invention. There is. Isn't there?
Yes, if you've made an invention, you've got the right to apply to file a patent application. But more importantly, you have the right.
Just before you go any further,
yes.
My understanding of my lord's question was, it seems, when I say so, a good question, is when someone makes an invention, are there any rights? And I just want to draw out that as far as I'm concerned, you've now given two answers, and I'd like to work out which one is your answer. One answer was no, there aren't. And I was putting it to you that actually there is a right. The right is a right to apply for a patent.
Yes.
But I don't, it's up to you.
There are, absolutely, no, there are.
Make sure I've understood where we are.
What I was referring to is there's no rights in the invention per se. There are rights that ensue from the invention. I have the right to keep it secret and to exploit the secrecy of that. I have the right to...
But that's a separate right. That's got nothing to do with the invention. No. Yeah. It's keeping it secret. Yes. Is the key bit there, because then you can bring in the equitable doctrine of confidentiality.
Yes.
And you may have rights through the equitable doctrine, but that's got nothing to do with it being an invention. It's to do with it being secret.
Yeah.
Yes.
Because if it's secret, you can protect it through confidence, even if there's no invention.
The right is determined by the patent itself. When you say, I want protection for that invention, you have no protection, no ownership for it. Let's say, for sake of argument, you decide not to file a patent application on an invention. It's a secret. Mm-hmm. What is it that you could, in what way could you transact that invention? You could sell the secret to the invention.
Well,
you could assign the rights to a patent in the invention. Right. Yes? But it is the right to be granted a patent. In the invention per se, the question is whether there's a right in the invention per se, unless you do something with it. Obtain a patent for it, keep it secret, or benefit from the results, the output of that invention. My invention may lie in the method of manufacture of something. I keep that secret. I benefit from the output of that invention, from the products that may be made by that secret method. But I'm keeping it secret. And I can't stop anybody else using that same method unless they've taken it from me. So it is, they've taken, in effect, some other right. They have taken the knowledge of the invention from me without consent, for example. And absolutely, there are rights that ensue from the invention. But the question, the point that I was suggesting in section 7.4 is the mechanism, and if I may, referring back to the words of Lord Hoffman, is the Patents Act contains a procedural machinery for determining disputes. Is that procedural machinery within the Act is who has the better claim to that invention? That is what the machinery is. The starting point is the applicant shall be taken to be entitled to the grant of the patent. And as I'm sure your lordships and ladyship know, there's very little that needs to be done to satisfy the requirements of section 13. You could even just say, actually, we fall within the provisions of section 7.2b, for example, without specifying how. And that is a permitted indication of the derivation of the right to be granted a patent. So what I'm seeking to suggest is that, or to argue, is that the first point is the applicant shall be taken to be entitled to the rights to the patent. Otherwise, the machinery that Lord Hoffman referred to is who has a better right to that invention. And that is what the law states. Shall and who has a better right. So by application of subsection 4 of section 7, the machinery is who should be granted that patent, not should nobody be granted that patent. And that is in the, in accordance, we say, with the underlying principle and the mechanism, this mechanism that Lord Hoffman refers to, how it actually operates. And there's been no suggestion whatsoever in these proceedings of who else might be entitled to the rights to the Dabbas inventions. Obviously, if nobody is entitled to the rights in the Dabbas inventions, does this mean that any invention made by an AI system owned by anybody...
The way you pose the question assumes there are rights in the invention.
If there aren't rights in the invention, then anybody's free to use it. And what does that mean to our AI industry? It means we're going to keep all of this secret, we won't invest in it, we won't...
Well, of course, you can exploit trade secrets.
If they can't be reverse engineered.
Yes. But, there are plenty of trade secrets which have proved to be commercially highly profitable.
And many that can be reverse engineered. And I think we would be doing a disservice to our AI industry if we're saying, actually, this invention is made by an AI system, you have no rights, nobody has any rights on it, anybody else can use this invention because nobody owns any rights in that invention.
I mean, as I understand, just turning to the particular facts of this case for a very, very short time, one of these patents is for some new food packaging thing.
Yep.
So it clearly couldn't be kept a trade secret if you're going to start selling food packaging in this fancy shape.
Absolutely. Now, I submit the light beacon could be reverse engineered as well. You just look at the pulsation of the light emitted by the light beacon. Absolutely. So these are not inventions that could be kept trade secrets. So, and while there are many inventions that could be kept trade secrets, it's actually very difficult. There are a great many that aren't. Also, it is very difficult to keep a trade secret in practice. If I may return now to section 13, and I have made reference already to the effect of failing to satisfy the procedure, or to meet the procedure, of subsection 2 of section 13. If he fails to do so, the application shall be taken to be withdrawn. The requirement is that the applicant shall, within the prescribed period, file with the Patent Office a statement identifying the person whom he believes to be the inventor or inventors. The learned judge, I may refer to the judgment, so this is in the main bundle I at page 90, paragraph 32. And this is about halfway across the second line of paragraph 32. I do not accept that more, that in rejecting the applications because the requirements of Section 13 were not satisfied, the IPO acted wrongly. Section 13 provides no mechanism for rejecting, but a deemed withdrawal. And I submit that there's a large difference between a deemed withdrawal and a rejection. And I submit also that you cannot use the provisions of Section 13 to refuse an application on substantive grounds relating to the nature of the invention, as Section 13 was not drafted to provide any such sanction. Of course, Section 13 does not refer to a natural person. It refers to identifying the person or persons whom the applicant believes to be the inventor. But the provision, I submit, does not require the inventor to be a person, nor does it require the person to be named. Dr. Thaler has satisfied the wording of subsection A of section 13.2 by saying I cannot identify any natural person who I believe to be the inventor or inventors. I submit that a normal reading of that provision, Dr. Thaler has satisfied it. And if I may make an analogy in this regard with, let's say, an engineering company that has it instructs its engineers to use daybooks or logbooks. They're quite standard in the engineering industry. And the employer finds a logbook, anonymous, leafs through it, finds an invention in it, and says, this is rather good, we want to patent it. We believe we're entitled to it because it is our logbook, it has our company name on it, and it is in the field in which we operate. But we don't know whose it is. Would it be right to deny that employer the grant of a patent for that invention when they can provide a very good indication of their derivation to their rights, solely because they cannot identify the person or persons whom they believe to be an inventor or inventors? They just cannot honestly say this was person X. We've made inquiries, we can't find it. Subsection B, which my friend Professor Abbott will come to in a moment, in terms of Dr. Thaler's rights, requires the applicant to provide an indication of the derivation of their rights, not to prove their right to the invention, mainly an indication. You can, for example, indicate by virtue of employment or assignment, or even by virtue of section 7.2 subsection B. That is all that is required. Furthermore, of course, section 13 is not the only section does not apply to all and every UK patent application. For instance, it does not apply to UK XPCT applications. If I may refer to, in the authorities bundle, to tab 3, section 89B provides that any statement of the name of the inventor under the treaty shall be treated as a statement filed under section 13.2. In other words, section 13 is, or section 13.2 is skipped in the case of an XPCT application. And for the Lordships and Ladyships reference in the supplemental bundle at tab M, we have front page of an international patent application, the publication numbers WO 2020 079499, and you can see at item 72 says inventor Dabus, invention was autonomously generated by an artificial intelligence, applicant Dr. Stephen Thaler, and while not in the bundle, I can assure your Lordships and your Ladyship that the same representations were made to the receiving office in the International Bureau of WIPO in respect of the nature of the derivation of this invention. The same addendum, if you wish.
All right, but then we have to start looking at the PCT provisions on
yes.
Who is required to be named as an inventor, if anybody.
Do
we have those?
We don't have those. The PCT says that you need to name the inventor. But the point really is that, and it's getting to the point that Section 13 is a procedural provision that doesn't apply in all cases, and therefore ought to be considered with some caution.
Well, when you say it doesn't apply in all cases, you've shown us section 89, capital B, subsection 1C, but apart from that, which is a deeming provision, are there any other examples?
There may be, if the European Patent Office were to grant a patent that's effective in the United Kingdom, but not within a UK, the UK Act.
That would never go through the UK office.
Absolutely, indeed, absolutely. But this is a prime example of the PCT, in effect, taking over some of the provisions of the Act, the procedural provisions of the Act.
But I mean, I just don't understand this submission, because you said that Section 13 doesn't apply in all cases, but the only case you've shown us in the statute where it doesn't apply is a deeming provision, which effectively says if you do X, then you're deemed to have done something under Section 13. So I'm just not following this.
I think the point, surely, is Section 13 cannot apply to a UK XPCT application. It cannot apply for two reasons.
Well, how does that help your argument?
Well, the argument is that Section 13 is a procedural provision, not a substantive provision in law. And Section 13 does not apply to a UK application filed following the PCT. It does not apply for two reasons. The first is Section 89B, says that a statement naming the inventor made under the PCT shall be treated as a statement under Section 13.2, but also the deemed withdrawal of Section 13, or the statement required by Section 13, is within 16 months.
I'm a bit puzzled by your assertion that it's procedural and not substantive. Section 13, subsection 1, says that the inventor or joint inventors of an invention shall have a right to be mentioned as such in any patent granted for the invention.
Yes.
And so on. And I think you agreed with me earlier when I suggested that that was a form of moral right and specifically a form of paternity right.
Yes.
So why is that not entirely substantive?
I'm referring to subsection 2 of Section 13. So one is a right to be mentioned, and the other is a statement that needs to be filed by the applicant. And the statement needs to be filed, needs to identify a number of things. And let's say if we go to the example I gave you of the engineering company that can't identify the inventor, they file a patent application. A few years later, the inventor turns up and says, oh, by the way, I'm the one who invented that. I can establish this. They have the right under Section 13(1) to be named. But at the time, does Section 13(2), would rather Section 13(2) prevent that engineering company from in effect being granted a patent solely because they can't identify the person who they believe is the inventor, the true deviser. They can't identify who that person is. Does that cause that invention to be unpatentable in terms of a patent will not be granted for it? And I submit that would be quite a harsh decision when actually the company can establish.
There are obvious answers to that problem, such as identifying the class of persons amongst whom the inventor may be. They can certainly do that on your hypothetical example. And why would that not be a sufficient requirement? We believe the inventor to be one of the following 10 people, but we don't know which.
Yes. They're providing a great number of people. Does that ultimately satisfy the requirements of Section 13? If they can't identify any person, would it still be reasonable to deny them that? Yes, if they can do, fine. If they can't, for one reason, they don't have the records. They can't identify that class of people. Practically, they might, but they may very well not be able to. If I may move on to the question as to, and this is where the debate has moved on to, is whether the designation of inventor could be left blank. And I've referred your lordships and ladyship to the AIPPI resolution, which suggested that and also the EPO Legal Board of Appeal suggested possibly not naming any inventor in the designation of inventor in cases of inventions made by AI systems. And in effect, Dr. Thaler has suggested this in Replacement Patents Form 7 when he stated that he can identify no person he believes made the invention. Form still identifies Dabbus as the inventor, the actual deviser of the inventions. Dr. Thaler would not resist removing Dabbus completely from the forms, should your lordships and ladyship be minded to follow the indications given by the AIPPI and the Legal Board of Appeal. I'd like to suggest, though, as I've indicated before, that it would be better to name Dabbus than not to name Dabbus. Leaving aside Section 13(1), which, as we've discussed, does not apply to an AI system, as AI systems do not currently have any legal personality and no rights, the issue really is a broader one of giving the public the information to question inventorship and entitlement. Sections 8, 12, 37, 72, for example. The public needs to be able to know who the alleged inventor is. But also in publishing those inventions that are made by an AI system to make it clear. Now, what a person with knowledge of the patent system might be able to infer from a blank inventorship declaration that the invention was made by an AI system, I submit this is likely to evade the understanding of most people. I submit also that leaving the inventorship blank could be a reasonable possibility, even in the case where the inventor was a natural person, as I've explained, the engineering company that can't identify a person or group of people who they believe may have contributed to the invention. Of course, should it be the case that the Legal Board of Appeal eventually decides in the appeals of the EPO that the inventorship form should be left blank. That could result in the grant of a European patent effective in the UK with no inventor designated. If I may, if I may pass the floor to Professor Abbott to...
Yes, thank you.
My lords and my lady, may it please the court, I'd like to discuss the issues in this case related to entitlement, the place in this case of the broader discussions of the AI's impact on the law, what's been happening in some of the other jurisdictions with the applications, and finally why it is that patents should be granted for AI generations to achieve the objectives of the Patents Act. Some of the earlier questioning has already addressed some of these, so I will be briefer in discussing them. But on the entitlement issue, it is accepted by the respondent, Dr. Thaler's assertion that Davis is the actual deviser of the invention. Davis cannot own the invention because it is not a legal person and therefore does not and cannot have legal rights in it. So this raises the question of if a patent is to subsist, who, if anyone, would be entitled to it. And as a preliminary matter, I should note the issue of non-human ownership of patents is not so out of the ordinary at all. As my friend Mr. Jahan has mentioned, most patents are not owned by inventors. Most patents are owned by artificial persons in the form of corporations and sovereigns. And they usually own these patents without any transfer of rights per se. Section 7.2 of the Patents Act, which is tab 1 in the authorities bundle, deals with entitlement, and it provides 3 mechanisms in which someone can be entitled to a patent. Subsection A establishes that patents may be granted to inventors. Subsection C establishes that patents may be granted to successors in title, which involves a transfer of rights. And subsection B provides that in preference to inventors, a patent for an invention may be granted to any person who, by virtue of any enactment or rule of law, was entitled to the property in the invention. This we submit as an open provision without condition that extends beyond the patents law to any rule of law. And as your lordship pointed out, it may be that an invention per se is not a property right, but certainly there is a property right in a chosen action. To apply for a patent, the patent application is property, an issued patent would be property, and even if we don't precisely call it a property right, if Dr. Thaler intended to keep the invention secret and exploit it as a trade secret, he would have quasi-property rights in this, such as the ability to exploit it and not to have people...
Well, hold on a minute. You say quasi-property rights, but there's lots of authority which establishes that confidential information, including trade secrets, is not property.
Quite right, indeed. And so the invention per se is not property. It is the right based on having the invention and being entitled to the invention to apply for it in a chosen action. But he would act with the invention as its owner and controller, whether or not it is formally recognized as a property right in the absence of applying for one.
But isn't Section 7.2b drafted on the assumption that there is some kind of property in invention, because it talks about the person who's entitled, at the time of the making of the invention, entitled to the whole of the property in it. It must be the invention.
Yes, my lady, and I believe that's referring to the fact that if you have an invention and you apply for a patent on it, the first thing you possess, if you are entitled to it, is a chosen action to apply for this patent, right? So in the same way that one would own a right to bring a lawsuit, one has the right to file for this patent, and the patent application is the piece of property, and the preceding right is the right to file for the patent. And that is the right which Section 7.2b grants to someone in preference to an inventor on the basis of any rule of the law.
Yeah, so this is what Lord Walker in Yeda described as some kind of inchoate property.
I would describe it as such, my lord.
Yeah.
7 Section 2b does not require a transfer of rights, which is the mechanism provided in Section 7.2c, nor does it require statutory entitlement, but also permits a common law basis for entitlement when it says any rule of law. We submit that, as articulated by Mr. Justice Marcus Smith, there is a rule of law that holds one can acquire title to property, to new property, by virtue of existing title to property. For example, when a farmer owns a fruit tree, he owns the fruit made by that tree. However, with due respect to the learned judge, that is not a rule of law that requires a transfer. Title to the fruit does not first vest in a fruit tree and then transfer to the farmer. The farmer derives entitlement by virtue of owning the tree, but title vests from the beginning in the farmer. This rule of law is seen in other areas of property law, for instance, when one owns livestock.
Okay, you're going a little quickly. I don't think there will be any dispute whatsoever that the owner of a fruit tree owns the fruit. Likewise, the owner of the cow owns the milk. Fine. But of course, in each of those examples, the produce is tangible property. We are concerned in the present case with something that is, even if you can describe it as subject to an inchoate property right, is intangible. And therefore, we need to be considering intangible examples. And I want to put one to you for your comment.
Please.
Suppose I own a radio transmitter and I broadcast a radio program using my transmitter. Now, by virtue of the Copyright Act, I will own copyright in the broadcast. If there are copyright works included within the broadcast, again, I will own those copyrights, or someone else may do. But at any rate, there may be statutory rights accruing by virtue of the Act. But if we look at the emanations from my radio transmitter, the electromagnetic radiation, do I have property in that?
I would say that is an electromagnetic wave, either as a tangible or a non-tangible phenomenon, is a thing in which there is an intellectual property right embodied. So, for example...
Yes, the intellectual property right is the copyright in the broadcast signal.
In that, yes, exactly. And so it is not
But
the
is there property in the radiation itself?
I would say, my lord, that the property is embodied in the radiation. It is not the radiation itself, but a characteristic of the radiation has an intellectual property right embodied in it. For example, if Dabbas was connected to a 3D printing machine and made this device, the device would be one tangible form of property, and if there was a patent owned on it, the patent IP would be associated with the thing, whether the thing is tangible or intangible.
But I've understood you to accept that there's no property in the electromagnetic radiation per se.
Correct. I would agree with that. But I would say that there is intellectual property associated with the electromagnetic radiation, in that the content of the electromagnetic radiation is subject to an intellectual property right. Now, as you quite rightly point out, the examples of the fruit and the sheep are tangible property rather than intangible property. But this being, in some sense, a matter of first instance, entitlement to a inchoate right in a patent application, and the fact that 7.2b is open-ended to any rule of law, we submit...
Well, yes, but the reason for the debate is that you rightly say that it's nothing to the point to say that Dr. Thaler isn't within section 7.2c, because Dr. Thaler isn't relying upon any a transfer of title. He is relying upon being first owner under section 7.2b, and in principle that must be right. But the question then is, what is the rule of law that means that Dr. Thaler is has, for want of a better word, ownership of the invention under section 7.2b in preference to the inventor Dabbas? And what you were submitting earlier is that the rule of law that's relied upon is the rule of law that establishes that fruit from a fruit tree belongs to the owner of the fruit tree, and milk from the cow belongs to the owner of the cow. And you have just accepted that those are both concerned with tangible property. We are concerned here with something that is intangible. And you've also accepted my example of a situation where there is an intangible emanation from an article where there is no property in that emanation.
Well,
so what's the rule of law?
Quite right, my lord. Let me answer those two. Just to parse what I said earlier, it was my submission that per se the electromagnetic radiation is not by itself a property right, but embodied in that intangible phenomenon is a property right because the content of the
because of the Copyright Act.
Indeed. Right, and so, but this is not, 7.2b does not say, by virtue of any enactment, it says any enactment or rule of law, so it doesn't require a statute. A common law rule will do it. And while the fruit of the tree, or accession doctrine, however you prefer to call it, it exists in tangible examples of applying to tangible sorts of property, we submit that it is appropriate in this case for those rules of law to also apply to an intangible piece of property in this circumstance. That the fundamentals in this case of what is property, what rights and obligations should one have associated with property, what gives someone entitlement to property, are all the same. It is that someone's property, whether a cow, a tree, or a machine, is making more property for its owner. And that someone should thus be entitled to that.
But that submission assumes what you're trying to prove, namely that there's property in the intangible thing in question.
Well, that he is entitled to it. I mean, it is a piece of property as a patent application, right? There is property in
Yeah, but we're talking about the situation prior to the patent application being filed. You're absolutely right. The statute says in terms that a patent application is a piece of property. But we have to consider the position before the application is filed.
Which is namely his entitlement to apply. And the rule of law we have submitted are several. Several common law rules of law grant him the rights to apply for a patent application. Justice Marcus Smith called this the fruit of the tree. The common law principle of accession, which we've supplied some information to you from Blackstone, which I could refer if you would be interested, but discusses that there is a common law rule under which one is entitled...
Well, I think we ought to look at that. So where do we find it in Blackstone?
Sure. So accession is in... we've provided two separate Blackstone references for two separate propositions. And I apologize it wasn't in the bottle, but this is Commentaries on the Law of England, Book the Second.
So which one should we be looking at?
Oh, they're both Book the Second, right? Sorry, these are different years. Blackstone. It is the one that looks like this on the cover, to be
right.
Yes. And if we turn to page 404, paragraph 6 says, "The doctrine of property arising from accession is also grounded on the right of occupancy. By the Roman law, if any given corporeal substance received afterwards by accession by natural or by artificial means, as by the growth of vegetables, the pregnancy of animals, the embroidering of cloth, or the something of wood or metal and vessels and utensils, the original owner of the thing was entitled by his right of possession to the property of it under such its state of improvement." This is a common law principle dating back to Roman times that essentially grants title to new property based on ownership of existing property.
But as you've pointed out, it's corporeal substance,
Indeed.
so it's tangible.
Well, but these same principles of accession do apply within intellectual property as well to intangible property. For example, with copyright, if I am the copyright owner of your broadcast, or you are the copyright owner of your broadcast, you have the right to make derivative works. And while that is a statutory right under the Copyright Act, that is a statutory right that is based on the common law right of accession. If you own a thing, you are entitled to derivatives of that thing. It is true, certainly, my lord, that this has never been applied in this precise context, and this principle is often applied in the context of tangible property. That being the case...
Well, can you cite to us a single case in which the doctrine of accession has been applied to an intangible?
I would refer to, while a statutory law, that accession operates with respect to derivative works under copyright, and in principle...
Well, I'm sorry, but you can't make a submission like that without referring to the relevant statutory provisions, because there is in fact no statutory right to a derivative work under the UK Copyright Act. It's a misconception. I appreciate that there are provisions to that effect in the US Act, but you don't find any such right in the UK Copyright Act.
Well, I would say as a matter of principle then, if it is not a statutory right in the UK, and my apologies for confusing US and UK law, if one is entitled to prevent others from making derivative works here and to make...
But that's because it's an infringement.
Well, yes, but so these common law principles, which...
It's not a common law principle. I'm sorry to keep on interrupting you, but we have to be clear in our terminology here. Copyright in this country is entirely statutory. And it is true that if you make something that is a derivative work, you may be infringing the copyright. But that tells you nothing about whether the right of accession recognised at common law, or the doctrine of accession, is applicable. They're two entirely separate questions.
Well, and my apologies, my lord, for not speaking precisely. What I meant to say was that these common law rules or principles are refined and also made the basis and reason behind eventual statutory enactments. That is a statutory rule, but it is at its heart based on principles of property ownership, including accession, first possession, sweat of the brow, right? The copyright statute is based on these long-standing understandings about what gives one right to property and what should be property. And so while infringement is not based on a common law doctrine of accession, the principles underlying the principle of accession are the basis for these laws, would be my submission.
Mr. Abbott, let me give you an example that has occurred to me of a case in which what sounds like the common law principle of accession is
My
related.
lord, I'm very sorry. Would you speak up?
Yes.
I'm sitting under the air conditioner. It's rather difficult to hear, my lord.
Let me give you an example of a case in which what looks like the common law doctrine of accession seems to have been applied in a copyright case. It's the famous first ever copyright decision, or some would say, of the High King of Tara in the Dark Ages, when deciding that St. Columba was an infringer of copyright and didn't own the book that he copied, which was the Gospel, and the famous judgment of the king was that to every cow its calf and to every book its copy. That, as I'm sure you know, is one of the earliest recorded bits of the Irish use of the Irish language as well, which is by the by. But it is, in one sense, reasoning by analogy between the accession of real property to the intellectual property.
Thank you very much, my lord, for that. The other thing I might say, if we were to depart briefly from accession, this Blackstone guide discusses also occupancy as a basis for ownership of property. And in some sense, occupancy, first possession, and accession are similar concepts. But occupancy and first possession is also a rule of law that operates throughout property law, for adverse possession or with obtaining rights to certain unowned wildlife. These are, again, tangible sorts of things, but the same principles, we would argue, apply to intangible sorts of property where, possession of something is a key indica of entitlement. In the Patents Act prior to 1977, and this is in the second Blackstone reference, which is the one appearing like this, on the very last page, in footnote 7, this goes a little bit further back than 1977, but it says, the patent is granted upon condition that the invention is new or new in this country. Prior to 1977, one did not even have to have any sort of relationship to an inventor to be the owner of an invention. They merely had to import the thing. And Justice Mr. Marcus Smith even gave the hypothetical of an alien coming from outside the galaxy, importing perhaps inventions, and in that case also was hoping that sort of importation might not be excluded from patentability.
Well, it's undoubtedly correct that formally in this country, you could obtain a patent by importing an invention from another country. And it was designed to incentivize manufacture in this country. But so what? Because that's no longer the law.
Well, indeed, Your Honor. And to be clear on this, it is our submission that there are rules of law that are based on the common law here, because there is no statute that says, if there is an AI-generated invention, you can't get a patent, or you can, and the AI should be listed as the inventor, and the AI's owner should own the thing, right? We have, as you pointed out, well, let me come to that case in a moment, but we have here an invention which otherwise meets all requirements of patentability, which has an acknowledged actual deviser, and will either have to have someone entitled to it, or in practice there will be no patent for anyone. On what grounds is Dr. Thaler entitled to it? Well, as there is no statute for or against him, it would have to be a common law rule of law, and there are several that, by operation of principle and analogy, we argue are appropriate to apply in these circumstances.
All right, but to come back to the question I asked you, as I understand it, you rely upon Blackstone's commentary, which on its face is concerned with tangibles, and you advance the argument the same principle should be applied by analogy, and that I understand. But you have not been able to find any case, any authority of the application of this principle to intangibles.
Not on the use of the common law rule per se, but it is our submission that the rationale behind that common law rule is the basis for subsequent statutory authority.
Thank you.
And the learned judge below did seem to accept the proposition that this rule of law could apply here, but that a transfer was required of the right from the actual deviser to Dr. Thaler, and that he did not see room made for in the law. But we would submit again that 7.2b does not require a transfer per se.
Well, that I think is clear, and I don't understand Dr. Barron to dispute that.
Okay, fair enough. Then I will say no more on that. Finally, I would like to reference the case that you brought our attention to, Franklin v. Giddens, and perhaps I am mistaking the reason for which you supplied the case, but to me, that was a case in which a court found that there was a real problem existing that wasn't solved by an existing statutory rule of law, and cried out for an equitable remedy, and the court was quite willing to provide one. I think our case is similar, is if you take a step back in all the discussions about substantive versus procedural law is, we have two perfectly good inventions here, which is the sort of thing the Patents Act is designed to encourage. Inventions which, as my friend said, often these cannot be protected by trade secrets, and if we have drug companies using AI to make cures for COVID or what have you, that sort of thing will need patent protection to make happen. It seems unconscionable or wrong that these perfectly good inventions should fail to be protected, even though Dr. Thaler has made these substantial investments in building an AI to do this useful thing. It may well be, as we have this new category of innovation, of which this case is the first, that we increasingly need to rely on people making, using, and developing AI to generate socially valuable innovation. And if we failed to grant a patent in this case, or if a patent was not granted on the basis of a procedural objection on Form 7, this would have...
There may be a good policy argument. It's not for this court to say one way or the other, but I mean, this is something that is occupying the attention of legislators worldwide. There's active consideration of this issue, as we see, for example, from the UKIPO consultation. So if it's felt that the current law is defective, no doubt Parliament will intervene.
Well, Your Honor, if I might briefly address that, and I'll move on to this as a point, I think it is quite right that Parliament should be discussing these sorts of things, but I also think it is quite right that we have active cases and controversies before the courts involving real harms to real people, and that the court could not avoid dealing with these until Parliament does or does not pass some new kind of law. Dr. Barron referenced the self-driving car example, and again, if a self-driving car or when a self-driving car runs someone over in this country, I submit the courts will not say sorry, we're powerless to help you until some grand unified law of artificial intelligence is passed. It's a commercial product. There are principles of product liability for dealing with that. And there is a victim in need of compensation, although Parliament may then change the law to do something else with this. You know, it is not true, we submit, that dealing with this one issue would topple a very delicately constructed house of cards. You know, whether a self-driving car is liable for an auto accident or Dr. Thaler gets a patent really have nothing to do with each other.
Well, to be sure, and I hadn't understood Dr. Barron to be running a floodgates argument.
Well, right, and I don't mean to take a facetious example, but let me take one closer to home, which is inventive step, and I quite agree this is entirely irrelevant to this case. For several reasons, not the least of which, as my lord kindly pointed out, Dabbis, even if it becomes a legal inventor as a result of today's hearing, that does not make Dabbis a skilled person. It has no impact on the skilled person test because a skilled person is not based on the capabilities of an inventor, but of an average researcher. And what my colleague, Mr. Jahan, was saying was quite right, I would submit, that the skilled person is not a natural person. The skilled person is a hypothetical heuristic problem-solving device for judges. There is no actual skilled person or group of skilled people. It is a set of capabilities that we attribute as existing to a hypothetical person. But in any case, again, whether Dabbis is listed as an inventor on this patent or not has nothing to do with the capabilities of average researchers whom are the basis for a skilled person standard. And when the case comes before your honors, or your lordships, regarding inventive step or sufficiency, these are issues that you are routinely used to resolving and which are very capable of solutions under the existing law. And it's all well and fine that Parliament may pass a Patents Act amendment to change if they don't like what you come up with today or in those cases, but still those cases will require resolution on the basis of the law as it is today. Some of these in some sense are policy points, but I think it would be wrong to characterize this as policy making. You know, we submit that it is entirely appropriate to consider the objectives of the Patent Act and parliamentary intent in statutory interpretation. There is one interpretation here which would say these patents are unpatentable, or these inventions are unpatentable because there is no way you can fill this form out correctly. And there is one interpretation that would say, you know, yes, AI-generated inventions are patentable. And
all right, well, I think you're now covering ground that Mr. Jehan has already covered, and I do have to keep an eye on the time.
Fair enough.
So by all means, if you've got further submissions on the question of entitlement, do let us have them. But otherwise, I think we should let Dr. Barron address us.
Certainly. And well, I had two final submissions that haven't been covered yet. If it would assist your honors, I could discuss a bit about the international cases and what's going on in the U.S.
Well, some brief information on that subject would be of interest, certainly. Thank you.
Thank you. So Mr. Jahan has already talked about what is happening before the EPO. Again, this is up for appeal for the Board of Appeal. It has only had a preliminary rejection from the Formalities Division. It is currently under appeal in the United States, in Germany, in Australia, and in Europe. It is pending before a dozen other patent offices at various stages. In the United States, it was rejected on three bases. That the Patents Act in the United States does not allow something other than a natural person to be an inventor, on the basis of jurisprudence from the Federal Circuit, which is the intermediate appellate court that deals with patent issues in the United States, saying that a natural person has to be an inventor, and on the basis that a machine could not conceive of an invention. The latter was dropped before the district court hearing, so it was simply those 2 points, the statutory interpretation point and the Federal Circuit jurisprudence. The Federal Circuit jurisprudence we distinguish on the basis that this question has only ever arisen in the context of whether or not you could have a legal person rather than a natural person as an inventor, namely, could a corporation be an inventor? And we're not here to argue a corporation couldn't be an inventor, but I would say there is a tremendous difference between a corporation and an AI, because a corporation can only act through human agents. And so whenever a corporation acts, there is some natural person or group of people who are inventors. And by not naming them on an application, even if they have no economic rights, we would be denying them due mention. And artificial intelligence, as this case demonstrates, is capable of acting as a traditional inventor without a person who qualifies as a traditional And as to the issue of statutory interpretation, the United States Patent Act is quite different from its language from the UK when it uses the term individual repeatedly, and so they are different matters of linguistic and statutory construction. There has yet been no court decision on this, though a district court decision is pending. Finally, we did have one rather significant update in the case that I would like to share with you. This was after the bundles were submitted and fairly recently. My learned friend is aware of it and has reserved the right to make an objection to introducing it, but it is also a confidential, until tomorrow, I'm afraid, update, and I could not
Well,
disclose
I don't think you can be disclosing as something that is confidential at this stage. I appreciate the position. From what you said, the position may change tomorrow, but why don't we cross that bridge when we come to it, and rather than place you at risk of breaching confidences.
Thank you. Perhaps, if it's agreeable to your lordship, we could circulate to all parties tomorrow's news to your clerks.
Yes, well, if there's something that would be relevant for us to know, it can be put in writing, and obviously that's without prejudice to any objection. There may be from the controller to us taking that information into account, but there's no chance that we're going to be giving judgment today, so I don't think there will be a difficulty from that perspective.
Very good. My final submission then was just on the objectives of the Patent Act and the big picture point about whether or not we want to allow patents for these sorts of innovations or not. And just very briefly, I would say, there are really three objectives to this. One is incentivizing innovation, which as an economic property right is really for the owner of a patent rather than the actual inventor, although the inventor may in some cases be the owner and is generally not. For investing in commercialization of patentable inventions, because indeed in the biotechnology industry, creating a new drug is the easiest part of this whole process. GSK would then have to go on to spend hundreds of millions of pounds to get a drug approved. So without the ability to have a patent for something like that, there's inventions that aren't protectable by trade secrets. And finally, in terms of disclosure, the Patents Act is designed to get people to disclose information they would otherwise keep as confidential commercial innovation. That's the whole concept of the patent social bargain, that one discloses this, gets a period of protection, and then the public can build upon that knowledge. And if it is the case that this sort of thing is unprotectable, it will simply drive the AI industry to whatever they can protect in that fashion, not be disclosing it to the public. And in all cases, we would argue, my lord, that allowing a patent on an AI-generated invention would accomplish all of the objectives of the patent law, while denying one would frustrate parliamentary intent. And I would like, if I may, to pass the floor to my learned friend, but we would appreciate the opportunity to reply to his submissions.
Of course. Yes.
I'm grateful. My lords and my lady, if it pleases, I propose to take matters in essentially three stages. First, I was going to take a very few minutes by way of introduction to explain at the very broadest level what the controller's position is on this appeal, but also, importantly, what the controller doesn't say on this appeal, and in the course of that to explain a little as well about the consultation process that is currently underway. Towards the end of that, I was going to deal with the state of play in other jurisdictions, but I think Professor Abbott may have covered all of that, so there will be very little certainly to say there. Secondly, I propose to look at the statutory framework, in particular at sections 7 and 13, and to show you in particular why the controller says that the judge and the hearing officer were correct to find that the inventor of an invention for which a patent may be granted must be a person. And then finally, having done that, I propose to deal with the grounds of appeal relatively concisely, having done the groundwork looking at the statutes and taking in some of the points that my learned friend has raised in court this morning. Most of my time will be spent, I've divided the grounds of appeal into essentially three heads in my written submissions, and I propose to take that course today also. Most of my time will be spent, I suspect, on section 7.2b, then the section 7.3, and section 13 rather more briefly. So that's the agenda, as it were, if it pleases. To start then, the controller's position is in essence that the hearing officer made the correct decision and the judge made the correct order upholding that decision. I'll develop this all in due course, but we can put it shortly in 4 points. First, the controller considers that Section 7 does not accommodate an inventor that is not a person. Second, it is common ground that Dabus is not a person. Third, Dabus is therefore not properly an inventor within Section 7. And fourth, that being so, Dr. Thaler is not, by virtue of any relationship with Dabus, a person entitled to apply for these patents and did not comply with Section 13. That, of course, my lords and my lady, is an application of the law as it is currently in force, because that is what the hearing officer had to do, and that's the same law the judge had to apply when reviewing his decision. The appellant has raised several points today that in my submission really go to what my friends say the law ought to be, what Parliament ought to have legislated if only it had seen what was coming in 40 years' time for reasons of policy. But this appeal isn't and can't, in my submission properly, be about that. The question for my lords and my lady is whether the hearing officer and then the judge correctly applied the law as it is. And on that basis, we say the answer is clear and it is in outline as I set it out a moment ago. Nor on the face of it is that answer terribly surprising, given that it is common ground that Parliament didn't have AI inventors at the front of their mind when they concluded the Patents Act 77.
Well, that I'm sure you are right to say is common ground, but my Lord Justice Birss raised a question earlier as to what one might call the state of the computing art at the time of 1977. Now, one's got to be very careful about that for the reason that my Lord pointed out, namely that people are apt to make assertions without checking whether they are well-founded in fact, and this court doesn't have the benefit of any evidence on the subject.
No,
but would you agree with what my Lord suggested was a better characterisation of the position, namely that by 1977 things called expert systems had certainly been conceived of. How far the technology had actually got by that point in time is perhaps a matter for debate, but certainly the conception was there.
I'm certainly not going to quibble with that, my lord, and that's why I put the submission as I do, which is to say not that it was unforeseeable or anything like that. I make no such assertion because I don't have the material for it, but simply to say that it doesn't appear on the face of anything that any of the parties to this case have seen to have been in the front of their minds. We can't properly assume this was all drafted with AI at the forefront of the drafters' minds. That's as high as I wish to put it, for exactly the reason my lord gives. Now, the distinction between the law in force and the law that might be desirable in future is important for another reason. As I was at pains to point out in writing, the controller doesn't come to this hearing to rubbish the appellant's point of view as to how our laws might better be framed, and it's certainly not the controller's position that the appellant's views about the need to accommodate AI in our law aren't worthy of respect, not at all. Indeed, the controller welcomes the fact that so many interested parties, including this appellant and his team, have engaged so fully in that broader conversation. Nor has the controller reached a concluded view that Dr. Thaler's suggestions about how the law might properly be framed in future are wrong. And it's for those reasons that the controller has underway a consultation process about the accommodation of AI in our law, to which I'll turn very shortly. Because if it is desirable that there be any change in our statutory IP law, then that needs to come about as a result of a conversation that ranges substantially wider than the parties to this hearing. With some of the points taken on this appeal, we are playing with bricks that sit very near the foundation of a carefully constructed statutory structure. Now, I don't want to put this too high. The controller isn't interested to make hyperbolic submissions about how the sky will fall in if you accede to any of my learned friends' arguments. But it is both reasonable and desirable for Parliament to be afforded the opportunity to come up with a coherent solution to a series of linked issues. My learned friend Mr. Jahan spent some time this morning discussing the test for obviousness, discussing the skilled person, one can imagine that common general knowledge would maybe be invoked if AI is going to creep into these various definitions of person that arise in the Patents Act. It's perfectly reasonable that Parliament should be afforded the chance to consider those things in the round, because they do form part of a coherent and linked structure in the statute already. In my skeleton, I set out some big policy questions that the debate touches on, that Parliament, in its fullest sense, including committees taking evidence and so on, might properly wish to consider when deciding how to accommodate AI. Those are not questions that I propose to answer today, and nor are they ones that the court could properly determine on the materials that we've provided. But they do serve as an illustration of the breadth of this issue. Also, as a matter of the approach to statutory interpretation, it is of note that the Patents Act 77 has been amended several times since its original reenactment, including at least, we counted 5 times, I think, in the last decade. Now, none of those amendments is germane to anything you have to decide, but it isn't as if Parliament hasn't had any opportunities to update or reconsider any part of the Act. They have, and they haven't chosen to accommodate the changes urged by the present appellant. And moreover, as I set out in my skeleton, I don't think we need to go to it, but for my lords and my ladies, note it's paragraph 44G, in my skeleton's at Core Bundle tab F, that's page 60. Parliament has made express provision for authorship and ownership of computer-generated works in statutes that concern other intellectual property rights. There are 2 short points that arise from that in my submission. First, Parliament thought that it didn't go without saying, on the face of the existing law, where property should lie in a machine-devised work. It needed and was appropriate for statutory provision in express terms. And second, although it's plain that they had the issue in mind, specifically in the intellectual property context, Parliament has declined to make, or omitted to make, such an amendment to the Patents Act 1977 at the same time it was considering the statutes for copyright and for designs. In my submission, that makes it all the more important.
In that regard, I presume you would rely upon the fact that the Copyright Designs and Patents Act 1988, as its name implies, made provision for patents as well as for copyrights.
Quite so, my lord, and even if that weren't the case, given that they were considering 2 major intellectual property rights, one might well say this has been considered in precisely the intellectual property context, and for whatever reason, Parliament has omitted to make such a change to the Patents Act or to the CDPA in the context of patents. That being so, it makes it all the more important in my submission to resist reading something into that silence when the reasonable inference is that it's a considered omission. Given the wide range...
I understand that submission, but presumably you would accept that the 1977 Act, like most pieces of legislation, has to be interpreted in the light of contemporary conditions. One can't simply put it in a historical box and say, oh well, we can only interpret it in the light, for example, of the technology that was available in 1977. That would be absurd.
I don't quibble with that at all, my lord. And none of these submissions I'm making is meant individually to be a magical answer that disappears the entire appeal, but these are factors that I say the court should have in mind when I say it's appropriate to be reluctant to read vast amounts into silence and to read big changes into silence.
No, Mr. Barron, I see that, but I'm struggling at the moment to see exactly where the point that you're making, that in the 1988 Copyright Designs and Patents Act, there was into copyright law, and I think it was the same time design law, the computer-generated work provision that you're talking about.
Yes.
To read across into that, the fact that the law in terms of patent law wasn't changed, because it might be thought the reason it wasn't changed is because it was assumed that patent law already provided that the property right in question would inure for someone who made an invention which involved computer-generated ideas or information. So, like the shape of a molecule or something, I don't know. But I mean, so I'm just not sure. I get the advocacy, and I get the point that one needs to ultimately look at the words of the act.
Which is what we will do.
Right. I'm just not sure what else one can really do in these circumstances.
All that I say is it's appropriate to be conservative in reading things into the act that aren't there when related things have been put into other acts and not this one. We will have to look at the provisions of this act to determine what they say. My lords and my lady will reach a view on the basis of that.
Yeah.
But I do say it is appropriate by way of background to look at what the overall picture is. And there are cases in which it's appropriate for courts to fill gaps in legislation. There are other cases in which it is not. And I say that these are good reasons to be conservative when looking at this legislation. As I pointed out earlier, the Controller's primary position is that reading this legislation, it's clear what the answer is, and that's as was found by the hearing officer and the judge. And that's the beginning and the end of the case. But I also say there are further reasons not to go in the direction that my learned friends urge on you to start filling gaps. That's as high as I wish to put it. Against that background, the UKIPO has launched a call for views on AI and intellectual property, and it was not limited to patents and certainly not just to questions arising on this appeal, but those issues were ones highlighted by the UKIPO's questions, and you've been taken to one or two of those this morning. Just by way of update, that call for views received a fulsome set of responses, of which there were 92 in the end. I understand that's a pretty impressive tally for this sort of thing, particularly on a topic that is, on the face of it, of greater interest to those in some technical areas than in others. And it's important that the consultation allows all manner of types of parties to take part, not just IP lawyers, but those with business and R&D interests engaged at the forefront of this technology. That's of particular importance here because the assertion that current AI technology is capable of inventing freely is a technically controversial one. Now, in this case, we will not go behind Dr. Thaler's assertion that Birss was the actual deviser of the invention. The UKIPO does not go behind those sorts of assertions because it would rapidly become overwhelmed if it had to carry out a factual inquiry each time. But it is clear that there is some controversy among those who are engaged in this field as to whether that is really true. So to extend the law on the basis that it will generally be true that AI can be the actual deviser would be particularly dangerous, extrapolating from what are only assumed facts in this case. My learned friend misspoke a couple of times when he said the UKIPO has accepted that Birss is the actual deviser of this invention. Accepted may be right, certainly doesn't go further than that. We've made no such finding, and nor did the judge. It's an assumption that what we're told is correct. My Lord Justice Birss wished to ask me something about that.
Well, I'm just trying to understand how that submission works. You stand there and tell me that you're not going behind the statement that Birss is the actual inventor, and then you tell us actually you don't believe a word of it. And you invite us to decide the case on the basis that you don't really believe it, even though you're standing here telling us you're not going behind it. I don't really understand that submission. I mean, you can tell us it's technically controversial. I get that.
That's all.
Take your word for it. But whether the law applies to it or not is the question we have to answer.
Yes.
On the basis of what's accepted, which is that for the purpose of this case, Birss is the actual deviser of this invention.
Yes. Well, all I'm saying is that there's a further reason to be cautious because that is a controversial assertion. My Lord said you understood it to be a controversial one. You understood my submission that it's a controversial one. The Controller is not taking a position that it does not believe Dr. Thaler's. We do not go behind that assertion, and I don't invite the court to do so either. We will continue this appeal on that basis. But where it comes to you, my lords, having been invited to refashion the law, or to fill in gaps in the law, a further reason to be cautious is that very factual basis is a controversial one.
But any decision would make clear that this appeal is being decided on assumed facts. and it would be clear what assumptions were being made by the court. So what's the problem?
That's absolutely right. So the determination of the answer in this appeal is to be made on those assumed facts, and I will not invite you to go behind them. And the controller, to be clear, doesn't either. My instructions are that the process is underway of working up the consultation documents for the possible policy options that might be followed up in light of the responses to the call for views, and it's hoped that that further process of consultation will be ready to start somewhere in the final quarter of 2021. So maybe in due course, following a proper process of consultation, Parliament may see fit to make changes to the law, but I do merely emphasise that in this case, we simply are to look at what the law is as it applies now. I don't think I need to say anything more about the US or the EPO proceedings, because I think it's all been covered by my learned friend Professor Abbott, but I will return to you after lunch with those if I think there is anything that I have missed. So my next move is to go to the statutory framework and personal inventorship. I think if it pleases my lords and my lady, that's something that it would make sense to do after the short adjournment.
Yes, certainly. All right, we will break there and resume at 2 p.m. Can I just ask you how you're doing time-wise? I appreciate you started later than you might have expected.
I think, in the most respectful way I can, that doesn't just depend on me. It's at the moment...
Very fair comment.
At the moment, it's fair to tell you I am on page 8 of a 25-page note. So that would suggest I've been speaking for about 20 or 25 minutes, I think.
So you might finish by 3:30, do you think, perhaps?
By 3:30, I would certainly hope to be finished, yes.
Yes, that sounds fine. Very good. We will resume. Lord Justice Birss just has a question he'd like to ask before we rise.
Yeah, Mr. Barron, can I just put this to you so that you can think about it over lunch and rather than interrupt your submissions? Let me tell you what.
Can I just ask you to speak up
yes.
to all three of my lords and my lady? There is an air conditioner right above me, which you can imagine I'm not terribly keen to walk away from.
It's probably a malign machine deliberately trying to... no, the question is this. I tell you what troubles me about this case. It's not really whether Mr. Thaler or Dr. Thaler is or isn't entitled to an invention directly. What troubles me is that one way of looking at the outcome so far is that what is being created is a new ground for revoking patents. So the hypothesis I want to put to you is this. Imagine for some reason the patent in this case was granted. Say because Dr. Thaler, from his perspective, lied and put his name down as the inventor, yes, when in fact he believes what he's told us is the position. And let's imagine later on someone finds out about what really happened and what the true deviser of the invention really is, and it turns out to be Birss, not Dr. Thaler. What I'm concerned about is that the logic which denies the patent in this case would create the ability for parties to come to court and say that these patents should not be granted and are invalid. And so while at the moment, because of the procedural context in which this matter is arising, it can be, you can stand there and present it as if this is an extension to the law. If you grant Dr. Thaler an invention, what I'm really worried about is whether it's an extension to the law already if you can refuse a situation, a grant of a patent in a case like this, when on the hypothesis that you're not challenging, there is an invention, Birss was the inventor, and on the face of it, forgive me, you're quite right, you're right to pick me up on that, the actual deviser. And on the face of it, the only conceivable human being who could be the person to apply for the patent would be Dr. Thaler. And so I'm worried that this is creating a ground of invalidity out of thin air. That's what worries me. I'm not asking you to answer it now, but I wanted to get that off my chest now and give you a chance after lunch to tell me the answer.
I'm grateful.
Right.